Mr. McLeod,
Contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt court taken into custody.
Really? That's it.
This court hearing is complete chaos from beginning to end. Mr. McLeod is facing charges for attacking a police officer. Instead of dealing with the charge, he argues that the court has no power over him and claims he doesn't recognize its authority. He interrupts constantly, raises his voice, and throws around legal terms that don't actually apply. Each time, the judge calmly shuts him down. Things get heated, and by the end of the hearing, the judge decides to have him held in jail overnight. Watching it unfold is both frustrating and oddly entertaining. Mr. McLeod is extremely confident in what he's saying.
Do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law before I accept that waiver to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here.
But the legal system quickly breaks down his arguments. Take note of how calm the judge remains. Despite the constant interruptions, he gives Mr. McLeod several chances to respond properly. The judge explains basic legal points slowly and clearly, showing a lot of patience. It's impressive, especially since Mr. McLeod keeps acting like he doesn't understand simple courtroom rules.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
One second.
and see why his attorney withdrew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend, to observe. They've participated. I'm removing them from the hearing.
At one point, there's an unexpected moment in the courtroom that feels completely unfiltered. You can almost sense what everyone in the room is thinking. It even explains why his previous attorney stepped away from the case. Mr. Mloud flips through a stack of papers, searching for some rule he believes will instantly fix everything. He seems convinced he's found a hidden loophole, while everyone else already knows how this will end. You have to wonder what he expects to happen. Does he really believe the judge will suddenly agree and dismiss the case? It's like watching someone try to win a game without knowing the rules. As the hearing continues, you can tell the judge has reached his limit. He remains professional, but his message is clear. None of Mr. Mloud's arguments apply to the situation. Judges are responsible for enforcing actual law, not personal interpretations or internet theories.
Mr. Mloud, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. Mloud, can we back it? Look at me for a second. Can we talk here?
I challenge subject matter jurisdiction. Nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
jurisdiction doesn't exist under the Constitution.
Your objection's noted. So, Mr. Mloud, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't.
What makes this even more surprising is that Mr. Mloud had the right to an attorney. Under the Sixth Amendment, he could have asked for legal representation, even if he couldn't afford one. Instead, he chose to represent himself and rely on arguments that courts have rejected for decades. The charge he's facing is serious. Assaulting a police officer can lead to heavy penalties, including prison time and long-term consequences.
I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. Mloud?
So I'd like to state for the record that
Mr. Mloud, stop.
the court can be.
Stop, Mr. Mloud. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
these
Mloud,
statutes.
I have other matters. Mr. Mloud,
Mloud.
you know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. Mloud, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So.
Mr.
in
McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. Sorry.
Fucking Joe.
This isn't true. You guys are
We'll have to
following
follow
unlawful
unconstitutional
orders. You're following
orders.
unlawful orders. It's not
Not a
constitutional
good
at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
Rather than addressing the charge directly or working toward a reasonable outcome, he wastes time arguing points that don't help his case. In the end, his approach only makes things worse. There's also a sad side to this. Some people genuinely believe they are above certain laws because of misinformation. But courts across the country have consistently dismissed these types of claims since the 1990s. Judges are bound to apply established law, not personal beliefs. By the close of the hearing, it's clear that Mr. McLeod's strategy has backfired. Instead of helping himself, he's added to his problems. That wraps up the breakdown of this intense courtroom moment. What do you think? Was he serious about his claims or trying to avoid responsibility?